All right. Well, good afternoon, everyone, and welcome to the webinar that we have prepared for you today on vaccination and employment. Obviously, this is an area that probably about 2 years ago no one would have thought would require a full webinar, but here we are. Just a brief introduction. My name is Rob Solt. I'm one of the litigation associates here at Bugbee & Conkle. And joining me today is Carl Habekost, who's the head of our employment protection. I assume most of the people on this are familiar with Bugbee & Conkle, but just a brief little plug. We are a small firm located in Toledo, Ohio. We're really a boutique firm that focuses on employment, workers' compensation, and labor issues. And we've been around for a while. We've been doing this for 70 years. We have a wealth of experience. We have attorneys in our office that have been practicing for almost 50 years, and all the way down to myself. And I've been practicing law for 10 years, so I'm not exactly a spring chicken anymore either. So without further ado, we'd like to get started today. And so Carl's going to start us off.
Given the fact we're doing this remotely, you may hear a dog bark from time to time, so we're asking your patience with us and everyone as we move through the vaccines and COVID-19. We are so much looking forward to speaking about something besides COVID-19. Nevertheless, this is a very important topic for the employer-employee relationship. Today, our goal is to provide you with topics for thought and perhaps even an action plan. Some of the questions that we pose do not have clear-cut answers, but we're going to ask them and we'll talk about them. And if you have any further questions at the end of the webinar, feel free to ask us. Here's primarily the three big areas we will speak to today: employer's legal duty, the employee's legal rights, and workplace safety issues. The large umbrella for the employer's legal duty is encompassed in the regulations of the Occupational Safety and Health Act. It's a very short sentence. It receives a significant amount of attention by the OSHA agency, which also stands for Occupational Safety and Health Administration, the federal agency which manages the Occupational Safety and Health Act, unless you're in one of those states that has their own state-run agency. But this short sentence actually puts legal liability on employers to provide a workplace that is free from recognized hazards that are causing or likely to cause death or serious physical harm. So we pose the question that we will address as we move through the webinar. Is COVID-19 a recognized hazard that causes or is likely to cause death or serious physical harm? Then, as we go through the webinar, we will talk about employees' rights. There are a plethora of legal rights that employees have, not only from a federal perspective, but also state and municipal laws. Today, we're just going to focus on a couple of them, but they're big ones. The Title VII of the Civil Rights Act of 1964 was the progenitor of a whole lot of federal legislation thereafter involving employees' rights. There's also the Americans with Disabilities Act that protects employees with disabilities. These two laws are managed, or I guess overseen, by the EEOC, which stands for the Equal Employment Opportunity Commission. So we're going to talk about how employers engage employees within the confines and the dictates of these two big civil rights laws. And finally, we are also going to talk about workers' compensation. In every state, there is a law that requires employers to provide workers' compensation insurance to employees who are injured in the course of and arising out of employment. Is COVID-19 a compensable workers' compensation claim? Could be, and we'll talk about that towards the end of our presentation. Well, now this is where guys like Rob and myself get excited, because you have the employer's legal duty and the employee's legal rights come together, and there are conflicts upon occasion. COVID-19 and the COVID-19 vaccine present an excellent opportunity for us to talk about conflicts that arise between what an employer thinks is right to do to protect everyone and the employee's rights to be protected from discrimination and retaliation. So, Mr. Soul, I believe this is yours.
That is me. Like Carl said, again, I apologize if you hear any noise in the background. I not only have a dog, but also a 2-year-old who likes to take the opportunity of whenever I'm on a webinar or a phone call to have a stomping fit upstairs. So I apologize in advance. We thought that it'd be important to at least set the stage a little bit and talk about how COVID, just generally what it does to the body and how it interacts, because we're looking at this from the employer's perspective, not only in some of the labor and employment avenues, but also through a workers' compensation lens. And so whenever you have a medical condition, it's imperative to understand how, in fact, we get to that medical condition. You would be very surprised the number of times that we will be in court on cases, and it's clear from just a baseline that the opposing counsel doesn't understand either basic anatomy or doesn't understand how different mechanisms of injury can and cannot cause an injury, and ultimately it becomes upon us to educate not only a hearing officer for the administration or a jury if we're in litigation. So just briefly, and I'm sure everyone has been very inundated with COVID-19 and has seen just a few news articles on it. Just generally, obviously COVID-19 is a virus, and it basically infects the body by entering the healthy cells and multiplying itself. I'm sure everyone has seen, and actually it works out absolutely perfectly, the graphic that we have. You got this little ball with these little bunch of spikes on it. Well, those spikes are what latches onto healthy cells and to burst through and to get into the healthy cells to take command. COVID-19, it typically it moves more through the respiratory tract because the receptors that the spiky portions can actually grab onto are more prevalent through the respiratory tract. So in general, it usually there are respiratory symptoms with someone who has who's contracted COVID-19. Now, the other thing that makes it very difficult is the symptoms vary in scope and severity. I'm sure all of you have seen that there are some people that are affected greatly. There are some people that aren't affected. There are some people that are on ventilators. Some people that they don't. I mean, I can tell you just anecdotally from a personal perspective, I know several people that have contracted COVID. Luckily, no one in my no one in my immediate family, but I do have family members that have been hospitalized with COVID. And whether it's a ventilator, whether or not someone needs to be intubated and be on a ventilator, or whether someone can receive outpatient treatment, it doesn't seem to there seems to be no rhyme or reason. So it is obviously, it's a difficult thing to diagnose, and it's a difficult thing. Well, in terms of diagnosis, the tests for COVID also vary in accuracy and range. And I'm sure most people have heard too, there are the nasal tests, there are the rapid tests. All of the testing still creates some issues in finding a diagnosis. I know one person personally who was recently hospitalized, had symptoms of COVID. They actually didn't do a test, but they assumed that she had COVID and was ultimately treated as such. Now they were able to do some scans of the lungs, and there was some pneumonia that COVID, as it invades the respiratory tract, there are some indicators that are present on the lungs that can be indicative, but they effectively diagnosed COVID to this individual by a CT scan of the chest as opposed to the actual test itself. So there is still a lot of variance. It's not like a simple mechanism of injury where someone breaks an ankle or someone has a physical injury. It varies so much person to person. So obviously we're going to be talking about vaccines, so it bears a little bit of importance to talk about how vaccines typically work. Now I'm not an immunologist, but typically what has been done for decades and longer than that even is a weakened form of the virus is injected in the body that allows the natural immune response to effectively learn how to fight the virus and learn how to prevent future infections of the virus. The COVID vaccine currently, we'll get into this a little bit, but the current COVID vaccines are actually, they use what's called messenger RNA. It's not actually a live weakened form of the virus, but instead it is this, it's basically the messenger RNA, and what it does is it blocks those spiky surfaces so that the COVID-19 virus cannot attach itself to the healthy cells. Currently, there are two companies that have vaccines that have been approved. Those are Pfizer and Moderna. They're both approximately 95%. They have a 95% efficacy. They both require refrigeration. The distribution of the vaccine, it varies greatly by state. And I would recommend that everyone check with your local health department and see what they're doing. I believe currently in Ohio, we're in still one of the introductory phases where if you're not a healthcare worker or first responder, it's limited to people 80 years or older. And I believe they're starting to open it up with some, if you have some comorbidities or some of the high risk conditions that could lead to a more serious infection. I know other states are trying to move it along faster. I believe I read just this past week that New Jersey, or one of the states out east, was trying to reduce the age they're requiring individuals to have how old they need to be to have the vaccine in an attempt to get it out faster. Something that will greatly impact this is how quickly the vaccines are able to get out. There are two more vaccines that are actually being developed. That is AstraZeneca and Johnson & Johnson. Johnson & Johnson specifically, that vaccine is, it's more of a traditional vaccine. What it utilizes is a common cold virus that is weakened, and it allows the information to the actual to the immune response to be introduced via that weakened form of virus. One of the benefits to that is it seems to be a single dose vaccine as opposed to a 2-dose like the Pfizer and the Moderna. Both AstraZeneca and Johnson & Johnson are currently just finishing up phase 2 trials. They have to go through a phase 3 trial, and if they're approved, that will be now 4 companies that are providing vaccines, and in theory will be able to have a greater impact. But the Johnson & Johnson, I don't believe the AstraZeneca is I believe that still is using the mRNA, but Johnson & Johnson is more of a typical vaccine. All right, so with that setting the stage, we'll move on to some employment law considerations.
All right, thanks, Rob. Here are, once again, large blocks of subject matter that we will cover over the next 10 slides or so. Should the vaccine be made available to your employees in a voluntary basis, or should employers and can employers make the vaccines mandatory? What do you do if your employees object? And I will say this right up front, if they object merely because they're afraid, or if they object merely because of political beliefs or persuasions, that is not a legally protected basis. It will have to be objections based on a disability or religious grounds. Should employers deliver the vaccines themselves, or should they contract with third parties? And are questions posed by third parties present a liability to employers? Do you have privacy concerns? Are there HIPAA concerns? Do the questions bring in concerns about the Americans with Disabilities Act? So we're going to touch base on all these big areas. We may not present clear answers for you, but at least it's topics for you to get your mind going and get thinking about it. Finally, labor management contracts. We decided not to get into this in depth in any particular slide. Those of you who work in a union facility understand the guidelines posed and the restrictions posed by the labor management agreement. So if you're going to get into the vaccine area, you need to get buy-in by the union, and then you're going to have to deal with whether or not you're going to need an addendum to the contract, or you can have a memorandum of understanding or whatnot. But that's really sort of a separate issue. We're not going to talk about that today. First question for contemplation: are unvaccinated employees a direct threat to themselves or the workplace under the Americans with Disabilities Act? There is an entire definition of a direct threat. I'm sure most of you, the HR, human resource people on this webinar, understand what I mean when I say direct threat. Some of the safety specialists on the webinar may have a different concept of what direct threat means. We're using direct threat terminology under the guidelines of the Americans with Disabilities Act. This is the definition that comes right off the EEOC website. A direct threat is a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. Now, I would throw this out there. The EEOC has already determined that the COVID-19 virus itself is a direct threat. We're talking about the vaccine, two different things. The reason I can say that the COVID-19 virus itself is a direct threat, because the EEOC has issued statements that allow employers to ask whether the employees have certain symptoms, which could mean that they have COVID-19. You're allowed to take their temperature. So I know that the experienced HR professionals out there see this as a really weird time we're living in, because you were never allowed to do such things before. that the EEOC has already determined COVID-19 pandemic is a huge threat. And so that in and of itself gives us some thought that the EEOC may come down and say unvaccinated employees are a direct threat to themselves or the workplace. And that'll have meaning as we move along in the webinar. How do you determine whether somebody poses a direct threat? There are 4 factors you need to analyze. So in other words, you have a fact pattern, you take these factors and you apply it to the fact pattern. The fact pattern is that you have an employee who does not want to get the vaccine. Are they a direct threat? And what do you do with that employee? So you take a look. How long is this risk going to go on? Well, as long as the COVID-19 virus and its variants are floating around in the air. That's a long time. Nature and severity of the harm. Rob has gone through the way that COVID-19 attacks the human body, and it's pretty severe consequences. Another factor is the likelihood that the potential harm will occur. Difficult to come to a conclusion just on that factor alone, but the imminence of the potential harm is pretty clear if people are working without social distancing, without masks, and they're not vaccinated. There will be a COVID-19 outbreak in that facility. Now, each of these factors are independent. So it's not a flow chart necessarily. It's not like the duration of the risk, yes or no. If yes, you go to nature and severity of the harm. It's not like that. These are all 4 factors that you need to look at in every situation to determine. It's sort of the process you go through and document to determine whether an individual presents a direct threat to the facility or your workplace.
Actually, I'd jump in just real quick, Carl, on 2 points. First off, the last thing you said about making sure you document everything. Mm-hmm. From a litigation perspective, obviously no one wants to have any of these cases potentially end up in court, but it's very important from our perspective, defending any type of potential cases, to have the documentation. So it's when going through this analysis, whether it is doing a memo or having a full written policy, as long as there's documentation, that is going to ultimately benefit everyone, at least benefit the company. The second point, just in terms of the likelihood that the potential harm will occur, one of the most difficult things about COVID-19 in general is that it's a moving target. And what's come out over the last few weeks is that there are mutations of the virus itself that appear, at least from an initial test, to be transmitted much easier than the initial COVID-19, which everyone would agree is fairly easily transmitted. You may have heard there was a variant through the UK that appears to be transmitted easier, whether or not the severity of symptoms, that appears to be about the same as the normal COVID-19. But there's also a variant that apparently has been prevalent in Columbus. So that's just something to keep in mind as well, that it's a moving target, and as the virus mutates, the analysis might change as well.
Yeah, excellent point. Documentation is critical. The documentation that you busy people prepare on the run in the midst of doing everything else will suddenly appear a year or 2 later under a microscope in a deposition where opposing attorneys will spend hours looking at. Am I right, Rob, on that?
Oh, absolutely. I mean, absolutely. I mean, I can tell you just in the cases that I've litigated, and I've litigated cases, not only just employment and workers' compensation cases, but all over the board. It's amazing how a whole case can turn on a handwritten note that someone prepared, at the time they were executing a document, or something that gives some insight into what was occurring at the time. And it's always better if from the employer's perspective, if you can say, well, this is how we did it. These are the notes that were taken at the time. This shows this is the process that we followed, as opposed to sitting there and saying, well, we did everything like we were supposed to, but you just have to listen to me. We didn't actually write it down. So contemporaneous notes, they increase the credibility of any point that you're trying to make. And honestly, whether or not any of these cases, with the vaccine just being rolling out, we're talking, a couple years down the road of before there's any type of potential actual litigation. I'm going to dive into a little bit later. We're just starting to see litigation on workers' compensation claims for COVID-19 itself, but with the vaccine, obviously that's going to be a little bit behind the initial the workers' comp stuff. So.
Yeah, but good point, because what you talked about, the variants of the virus, the changes in that regard will impact your analysis on the likelihood that the potential harm would occur and the imminence of the potential harm. So it's a moving target indeed. Okay, here's a good question. What are you going to do if somebody's not vaccinated? Are they a direct threat? So you go through the analysis we just went through. Are there any reasonable accommodations? And I'm going to get into this a little bit further in some more slides. But to answer this question, yes, you can exclude unvaccinated employees if you've gone through the analysis that they present a direct threat and it's a violation of your well-known policies. Now, are there reasons? Now, that doesn't mean you fire them automatically. That just means you're protecting your employees. Those of you who have heard other webinars we have done have heard us say that when all else is lost, you protect your employees. You look after the welfare, the health and safety of your employees. And if you can document that and you have done the best job you can, then I relish the opportunity to have an agency who allegedly is out there to protect employees come after you. If you do the best job you can to protect your employees, always have that foremost in mind, then most of the time everything's going to work out. Okay, now we talk about reasonable accommodations. What are reasonable? That involves an interactive process. You have to talk to the employee. You definitely should already have a job description that lays out the essential functions of the job. You are not required to create an entire new job for this individual, but you are required to analyze whether or not there's some accommodations that you can provide to allow that person to continue to work. Reasonable accommodation in this case may be remote work. That doesn't work for somebody who's a machine operator, but it would work for someone who works in an office or in a sales position. Okay. Is the COVID-19 vaccine considered to be a medical exam under the ADA? Once again, employers cannot go around willy-nilly. There is protection for employees because there's a couple of different laws that get implicated when you start just saying, I don't like the way you look. I'm going to, need you to go see a psychologist because you look weird. That when you start down that road, then the Americans with Disabilities Act is going to jump up out of the ground and bite you. Now, the vaccine itself is not a medical exam. The EEOC has stated that very clearly by virtue of publication on December 16th, 2020. So that said, you can require the vaccine because it's not a medical exam. There are a whole bunch of other issues that we'll talk about in a little bit about that. Okay. This is what I meant by other issues. Now, I don't know of a healthcare provider that's going to give a vaccine for COVID-19 without getting some more information from you. That really is, I think, almost akin to a flu vaccine as well. They want to know a little bit about you. Do you have a pre-existing condition that would make you vulnerable to getting really, really sick or dying if you had the COVID-19 vaccine? So even if you hire a third party to give the vaccine, the questions that they ask on a pre-screening basis may be prevented or may give you some problems under the Americans with Disabilities Act. So that's the answer to this question is yes. You must show that these questions are job related and consistent with business necessity. Two exceptions. Number one, the employer makes the vaccine voluntary. What is not on this slide, if we were in a room together, I would go around picking some people who I know are very knowledgeable. What I didn't put is the vaccines are voluntary and answering the questions are voluntary. So if the vaccine's voluntary, also answering these pre-screening questions are voluntary. The employee can voluntarily answer the questions or they cannot. The other exception is the employee receives vaccinations not at a third party, not contracted by the employer. Okay, I used a double negative. That means just like you get the flu vaccine, go to your doctor at your convenience and you get a flu shot. You go to the pharmacy, you get a flu shot. That's what this really means. Employee receives the vaccines at a third party that's not contracted by the employer. Can you require proof of the vaccine before you let somebody into your facility? So the point of this slide is merely requesting proof of the vaccine does not violate the Americans with Disabilities Act. So the EEOC has said, that's all right, you can ask for proof of vaccine. But where employers get into trouble is they don't stop there. It's the same thing with attorneys. Many years ago when I was a hearing officer, and I used to hear attorneys moving along fine and everything's fine, and then they ask the question that they shouldn't have asked. Well, it's the same thing with this. Are you vaccinated? Oh, you're not? Well, how come? You had, did you have something else going on that kept you from being vaccinated? So, just that simple, innocent question can get an employer into trouble. So simply ask for proof. And if they don't give you the proof, then you've got to go, decide how you're going to handle that. You're going to let them in the facility? Are you going to keep them out of the workplace? Will you end up firing them? There's a whole host of issues that flow from somebody who is not vaccinated. But simply, yes, you can ask for proof of vaccination.
And I'll just point out to Carl, I've seen when someone actually gets the COVID-19 vaccine, it's a little bit different. It's not like a typical chart entry into your medical records. They actually just give you a little card where they state, what type of vaccine you received, whether it was Moderna or Pfizer, and what your next date, what the second date of vaccination is. So it's not providing what I would consider sensitive medical information. It's just simply saying they got the vaccine. So.
Okay, good. how are you going to deliver the vaccine? Are you going to make it mandatory or is it going to be voluntary? We've touched on this. What do you do if employees object? And how are you going to have it administered? So we can move through some of these slides relatively quickly. Mandatory. It all needs to be put in context. If you're a long-term care facility, that's what I mean by residential care, schools, healthcare facilities, clearly people who are on the front lines being faced with exposure to COVID-19 are more inclined to want to get the virus, those employees. The question is, does the employer make it mandatory? I still like to analogize this to the flu vaccine. Most of our healthcare clients make it mandatory for the employees to get the flu vaccine. Do you have a business necessity? Yes, you are providing health care to sick individuals. The COVID-19 is a pandemic. It's everywhere. As a healthcare provider, you're exposed to it. The business would not function if all of the employees are sick with COVID-19. So I think that qualifies as a business necessity. You have heard Rob talk about it, and I'm going to hammer away on this now for the next few slides. You need to develop written policies. And in this particular case, for a mandatory vaccine, we recommend you have the policy in writing. You say the purpose of the policy. And we can throw in that general duty clause that was one of the first slides about OSHA. Can say something like, in accordance with the XYZ's duty to provide and maintain a workplace that is free of known and recognized hazards, we hereby adopt this policy to safeguard the health of our employees and their families, our customers, patients, visitors, and the community at large, blah, 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 and blah. So, make it in writing, have the purpose, describe the procedure, how is it going to be done, is human resources going to manage this, and if somebody has a problem with it, they want to be exempted from the policy, then you need to have in mind, and even maybe mention it in the written policy, about requesting an accommodation. So those are the high points for mandatory vaccine policy. Voluntary. Most of our clients are hedging towards this voluntary vaccine. There is what I will call angst. It's that cute little word I learned years ago. It just means strong anxiety, concern, fear, that they have an angst about this vaccine. It's a brand new vaccine. It was developed and prepared in lightning speed. There, however, has been sufficient testing. The drug companies prepared this according to proper protocol. So at least from what I've been able to pick up, the vaccine is safe. Employers need to educate their employees on that fact, that the vaccine is safe. It is critical for the safety of the workplace. And you can find ways to encourage employees to get the vaccine. There are all kinds of ways to do it. I would say leaders need to put their money where the mouth is. Go get the vaccines first. The management, and show the employees that management is committed to this. You can also incentivize people to get the vaccine. We have one client who decided this. They were going to provide 4 hours of paid time for their employees and also provide childcare so that they can go get the vaccine. So you can come up with all kinds of ideas that don't violate the law to incentivize your employees to get the vaccine. So that's where most of our clients are going as far as the voluntary vaccine goes. Now, the million-dollar question. You know, 99% of what employers and especially human resource people do is enjoyable. You take care of your people, things work fine, you develop these policies, people like them, they follow them, and then there's the 1% that takes up 99% of our time. So that's what we're going to talk about. What do you do if somebody objects to getting the vaccine? Well, I indicated early on that there are two legally protected reasons for somebody to object to getting the vaccine. One is disability related. The other one is religious related. In both of these, you need to do investigations. What do I mean by that? Disability related, at this point, and I would mention we're going to talk about it at the end of the webinar, but this is where you need to have HR people and supervisors trained, because your employees really don't quite always use the right words. You know, they're not going to say, I have a disability and I therefore request a reasonable accommodation. But they may use different words. Bottom line is they think that maybe they have severe asthma. I'll just throw that out. Or maybe they have severe diabetes and they're very concerned about getting the vaccine. Okay, well, they're concerned. But is that a valid basis to avoid getting the vaccine? That means you need to do a little bit more investigation. Perhaps at this point, you're doing a direct threat analysis. You can ask the employee to sign an official piece of paper that indicates that they're interested or they're requesting an exemption from the company's vaccine policy. At that point, they will authorize you to contact their attending physician and just ask the physician if they can provide you verification or confirmation that the employee is exempt from getting the vaccine. You can ask the reason for that or not. I mean, I would recommend in this situation, the less information you ask for, the better, but it does behoove you to do your due diligence and ask confirmation from a medical provider. Then at that point, you go through the reasonable accommodation interactive process and perhaps conclude that this employee on a temporary basis needs to be out of the workplace. You can revisit that in 4 weeks, 8 weeks, whatever time limit you come up with. Maybe they can do their job remotely. You're not required to create a new job for them. So if they can't perform the essential functions of the job, then you have to decide how you're going to handle them as far as continued employment. Religious accommodation is a little bit different. I only say that because the standard for a reasonable accommodation is a little different. I threw the sincerely held religious belief question out there. Several years ago, I did a webinar and we had a picture of an employee who was a member of the Church of the Tattoos. That is tattoo, T-A-T-T-O, you know, just like people who get ink on their skin. And so I throw that out there because the law presumes that a religious belief is sincere. You can do a little investigation and maybe you'll find evidence that this is all a hoax by your employee, but it really can be a waste of your time. You're better served to see if there would be an accommodation. And I always recommend you ask the employee for what do they have in mind? You know, well, what kind of accommodation? And if you can't accommodate that, then you got to deal with how you're going to have that person around or not down the road. All this needs to be documented, by the way. So we've touched base on this. Most employers do not have the resources to self-administer the vaccine. You have all kinds of concerns: refrigeration, supplies, personnel. I did want to just bring this back up. Even if you hire a third party to do the vaccine, you have concerns about pre-screening questions. That is stated with the caveat that Attorney Solt just mentioned, that the questions are benign in nature. They're vanilla. They're not really getting into details. And what is not in this webinar, as far as the slide is concerned, is this strange law. It's called GINA. That's the Genetic Information, what is this? Genetic Information Non-Discrimination Act. Sorry about that. It's not a law that we run into very often. But if you're asking questions about and family members and grandparents and all that, that could be interpreted to be genetic information, then you start having problems with that law. So I've hammered away enough in this webinar that you need to be careful what kind of pre-screening questions you ask your employees or are asked by a third party that you contract with to deliver the vaccine. I found this to be an interesting question because I spent a lot of time and money learning OSHA and the regulations, and I don't have an answer for this. If somebody out there has a very clear answer, I would like to hear it. I know that this is being talked about and considered by high people in the Safety Administration and the federal government anyway. But is the COVID-19 vaccine considered to be a mitigation or abatement? That means gonna like wipe it away. You're gonna wipe away the hazard of COVID-19 with this vaccine. So is there enough evidence to establish that the vaccine abates that recognized hazard of COVID-19 under the general duty clause? That's one of the very first slides we just reviewed. The employer has the duty to provide a workplace that is free of recognized hazards that are causing or likely to cause serious harm or death. And if so, are employers required at that point to implement the vaccine? Because at that point, then you got trouble with OSHA. And you could open yourself up potentially to some lawsuits. So this is one of those questions that didn't really have an answer. I'm just throwing it out for a topic for discussion.
All right.
Yep.
Back to me. So we want to talk just briefly about some of the considerations under workers' compensation in Ohio. So looking at the definition of an injury, and we'll kind of go through some COVID claims just briefly, and then what happens if there's a reaction to the vaccine. So in Ohio, the allowance for a claim for workers' compensation, it's a statutory definition of an injury. And so an injury includes any injury, whether caused by external accidental means or accidental in nature and result, received in the course of and arising out of the injured employee's employment. So that sentence right there has created, 50 years worth of workers' compensation work, give or take.
At least.
And that right there kind of boils down a lot of what we do. Injury itself can also include occupational diseases. So a repetition injury has been determined to be a repetition, like a carpal tunnel syndrome. It's not one discrete injury or one discrete event, but multiple different repetitions cause that condition. Also, exposure injuries are under this. So looking at asbestos claims, if someone is exposed to asbestos in the employment and years later they develop asbestosis or any of the asbestos related like mesothelioma, those are also they qualify as an injury for an allowance for workers' compensation. Well, what about transmitted illnesses normally? So the flu and the cold, like colds, typically these are not allowed conditions, partly because the burden of proving that the injury occurred and was arising out of the employment is on the injured worker. And it's very difficult to say that you picked up a flu or a cold from your place of employment just because if you're a member of the public, you're typically out and about, and there are a variety of different ways you can contract something. It's not not quite like an asbestos claim where you have a fixed situs of exposure over a long period of time. So typically, we've seen very few of these claims be allowed.
Mm-hmm. Hey,
What
Rob.
about, yeah.
Can I just throw this out? I know you've already covered it, but it's always been a head scratcher to me how a COVID-19 claim can get allowed when it's prevalent throughout the entire country. Like, that's the definition of a pandemic.
Well, that's a great question, Carl. And it kind of goes right into the next slides that we have. Our office, we've dealt with a handful of cases or claims that have come through where someone is saying that they contracted COVID in the workplace and they want an allowance. Now, so we've seen a handful of these cases, and if you are a frequent listener to our webinars, we previously have done some COVID cases, webinars where we did a case study about some of the various claims that have been that have gone through the administrative process. The bottom line is at this point, through the Bureau of Worker or through the Industrial Commission, we've had claims that have been allowed for COVID-19. And actually, we had one claim that the injury they claimed was coronavirus. Well, it's not technically an injury, but COVID-19 is the resulting disease that results from exposure to the coronavirus. But in theory, these should follow the similar pattern than the standard cold or the flu, because how, like Carl said, how is it possible to prove that you contracted COVID-19 at your place of employment? Now, there are a few areas that you could make a pretty decent argument. Some of the cases that we've seen involve charged nurses for a COVID unit at a retirement home. Well, that seems to be that they would have a greater likelihood of contracting COVID through the employment than they would other places. However, that would be under the assumption that they were not wearing PPE or proper PPE at their place of employment, and that they effectively lived in a bubble and had no contact with anyone else at all. Like I said, statutorily, the burden is on the injured worker. The reality is a lot of the hearing officers have viewed this as that not quite the same in regards to the COVID claims. The other thing that we've seen is it varies dramatically what conditions they're actually looking for. Typically, there needs to be some type of discrete injury. Okay, well, if you tripped and fell and you sprained your ankle, your allowance would be for a sprained ankle. Or if you have some type like a torn rotator cuff, those are discrete injuries. What if someone just tests positive for COVID-19 but is asymptomatic? It's somewhat confusing as to what type of treatment they would receive and why they would want an allowance. But nonetheless, we've had a couple of asymptomatic cases that have come through our office that have been allowed. And another one of the webinars we did dealt with some of the compensation that someone who tests positive to COVID and has to be off of work during the quarantine period is allowed. So I'm not going to dive into that, but effectively that was the value of some of the claims that we've seen. It's just there's some, they get some compensation, but not any type of medical treatment. The other thing to consider with these COVID claims is that I mentioned COVID's a moving target. We still don't know the full extent of how this can affect the body. This past summer, with some of the studies, they found out that myocarditis is a possible side effect, which is an inflammation of the tissue around the heart. So there are potentials that we're still at the tip of the iceberg learning about this. We in our office, we've had a lot of discussions that we're looking at these that potentially could be similar to an asbestosis claim or an asbestos claim. Where, so anyway, we've had a lot of discussions. If someone has an allowance for a COVID-19 claim and 15 years down the road develops some other issue, would that be a potential allowance? And we think that there's a potential in that route. So we counsel a lot of our clients that we really should be taking an active role in defending these COVID claims early on. All right, so what happens if someone has a side effect to the vaccine? So typically, as we know so far, that there are some side effects, at least to the Pfizer and the Moderna vaccines. The typical side effects are soreness at the injection site, that being the most common, but also headache, chills, fever, fatigue, joint and muscle pain are also possible. And typically after the second dose is when a higher percentage of people are experiencing these side effects. So we have to kind of look back to see if someone has a mandated vaccine and has a side effect, would they have the possibility to file a workers' compensation claim for receiving the vaccine? And we've discussed, and we believe, yeah, potentially they absolutely could. Now, whether or not that's going to be a high-value claim, typically these side effects are mild and last a day. It's questionable as to what the value of a workers' compensation claim would be, but that certainly does create a possibility. All right, well, we're almost at the end, so just Carl and I, we've got kind of the last conclusion thoughts to the general conclusions that we want to just have to beat over your heads our draft a vaccination policy, anticipate some of those accommodations, and train your HR and supervisors as how to effectuate your plan. So
this is like our action plan we recommend.
Yeah. So with that being said, if there are any questions, please feel free to either email Carl or myself. We appreciate you bearing with us and listening to our presentation, and we hope to hear from you, and hope to see everyone back again at the next one of these webinars that we will be doing.
No doubt. This, we hope, is our goodbye kiss to COVID-19 webinars. There are so much other new regulations and new law that is going on even right now as we're talking. There's some new regulations that are being promulgated, and with the new Biden administration, there will be more. So we're looking forward to speaking about something besides COVID-19. But we thought this was a very important topic for employers to at least be aware of and understand some of the concerns and some of the issues that they need to deal with. So I echo what Rob said. We're very grateful you took the time to spend with us today. We hope you found it profitable and meaningful. Feel free to ask us questions.